The Scottsboro Boys case began on a freight train, not in a courtroom, not with a careful investigation, not with a jury weighing evidence in silence. It began on March 25, 1931, in the hard years of the Great Depression, with young people riding the rails through the South, looking for work, safety, or simply the next town. By April 9, 8 black teenagers had been sentenced to death. Their names were Haywood Patterson, Olin Montgomery, Clarence Norris, Willie Roberson, Andy Wright, Ozzie Powell, Eugene Williams, Charlie Weems, and Roy Wright. Most of them were still boys. All of them were black. And in Alabama in 1931, that fact shaped almost everything that happened next. This is not only a story about a false accusation. It is a story about what happens when a legal system performs the rituals of justice while denying the substance of it. A courtroom can have a judge, a jury, lawyers, witnesses, and verdict forms. It can still be unfair. That is what the Scottsboro case forced America to see. The train was moving through northern Alabama when a fight broke out between black and white passengers. By the time it reached Paint Rock, Alabama, law enforcement and an angry crowd were waiting. 2 white women on the train, Victoria Price and Ruby Bates, accused the 9 black teenagers of rape. In the Jim Crow South, that accusation carried lethal force. It did not enter a neutral system. It entered a world where black defendants could be presumed guilty before evidence was tested, where white public outrage could become courtroom pressure, and where the possibility of mob violence was never far from the courthouse door. The boys were taken to Scottsboro. The trials moved with astonishing speed. Within days, life and death cases were pushed through court. Lawyers were present, but they had not been given the time, resources, or clear appointment needed to investigate, prepare witnesses, test the state's evidence, or build a real defense. In form, there was counsel. In reality, there was no meaningful defense. That difference became one of the central lessons of the case. The law can say a person has a lawyer, but if that lawyer has no time to prepare, no chance to consult, no real ability to investigate, and no structure to defend a capital case, then the right exists mostly on paper. For the Scottsboro Boys, the paper version of justice moved fast. The human cost moved slowly. 8 of the 9 were convicted and sentenced to death. Roy Wright, the youngest, received a mistrial after the jury could not agree on punishment. But the verdicts did not end the case. They ignited it. Across the country, the Scottsboro Boys became a symbol of racial injustice. Civil rights activists, lawyers, journalists, labor groups, and ordinary citizens began to follow the case. The question was no longer only whether 9 teenagers had received a fair trial. It was whether the courts of a state could protect black defendants when public opinion demanded punishment. The first major constitutional turn came in Powell v. Alabama. In 1932, the United States Supreme Court examined the original proceedings and reversed the convictions before it. The court focused on due process in a capital case. The right to counsel, it said, had to mean more than a last-minute gesture. The defendants needed a real opportunity to secure counsel, consult with counsel, and prepare a defense. Powell did not end the Scottsboro case, but it exposed the emptiness of a trial where the most basic protection existed only as a courtroom formality. Then the state tried again. New trials followed, convictions followed, appeals followed. And the case revealed another layer of bias, one older and deeper than any single trial. Who was allowed to sit in judgment? In Norris v. Alabama, decided in 1935, the Supreme Court confronted the exclusion of black citizens from jury service. The question was not simply whether one jury was unfair. It was whether the machinery that created juries had systematically kept black citizens out. The court held that excluding black citizens from grand juries and trial juries because of race violated the Equal Protection Clause of the 14th Amendment. That ruling mattered because jury discrimination can hide behind routine paperwork. A county can keep lists, it can summon jurors, it can claim that procedures were followed. But if qualified black citizens are systematically kept out, then the jury box becomes another instrument of racial power. The Scottsboro case showed that bias does not always announce itself. Sometimes it appears as speed. Sometimes it appears as a lawyer appointed too late to matter. Sometimes it appears as a jury list where an entire community is missing. Sometimes it appears as a courtroom that looks official from the outside, while every practical condition inside is tilted toward conviction. In 1933, Ruby Bates testified for the defense that no rape had occurred. The prosecution's case was challenged again and again. Still, the legal process did not simply stop and repair itself. That is another reason Scottsboro matters. Even when a system is exposed, it can keep moving. Even when higher courts reverse convictions, people can remain trapped in retrials, prison terms, parole battles, and public suspicion. The Scottsboro Boys did not walk out together into a clean ending. Their outcomes differed. Some charges were dropped, some sentences were changed, some were paroled, some spent years in prison. Clarence Norris received a pardon decades later in 1976. In 2013, Alabama granted posthumous pardons to 3 of the men whose convictions had still not been fully cleared: Haywood Patterson, Charlie Weems, and Andy Wright. But a pardon after a life has been damaged is not the same as justice delivered on time. The case became part of American legal history because it forced 2 questions into the constitutional record. First, does the right to counsel mean anything if the defense is not real? Second, can a jury represent justice if black citizens are excluded from the box? Those questions did not belong only to Alabama in 1931. They reached into the structure of American criminal law. Powell v. Alabama helped build the principle that counsel in a serious criminal case must be meaningful, not symbolic. Norris v. Chem. Alabama confirmed that racial exclusion from juries is not a local custom the Constitution can tolerate. But the deeper lesson is more uncomfortable. The Scottsboro Boys were not failed by one broken piece. They were failed by a chain, a racially charged accusation, a crowd ready for punishment, a rushed prosecution, defense in name more than function, all white juries, courts that had to be forced again and again to confront what was happening. Each link made the next one stronger. That is how judicial bias can work. It does not always depend on one person saying the quiet part aloud. It can live in timing, access, fear, jury selection, local custom, public pressure, and the assumptions people bring into the room before testimony begins. The Scottsboro Boys case asks us to look at the difference between procedure and justice. Procedure asks whether the forms were completed. Justice asks whether the accused could actually defend themselves. Procedure asks whether a jury was seated. Justice asks who was kept out of the jury pool. Procedure asks whether a verdict was announced. Justice asks what forces shaped that verdict before the first witness spoke. 9 teenagers boarded a train in 1931. Within weeks, 8 were facing death. And for years afterward, the law moved faster against them than it ever moved toward the truth. That is why Scottsboro still matters. Because if the law can move that quickly toward punishment, and that slowly toward correction, then the real question is not only what happened to the Scottsboro Boys. The real question is what a fair trial is supposed to mean.